this year I thought rather than just talking about one thing, we tried to hit a few topics of some things, a couple of follow-ups from things we've talked about in the past, and then a couple of new things this year. And so we're going to start with just a little bit of a recap. The last time we talked about the implements of husbandry regulation, the weight and size restrictions on farm equipment on the road. Things were still kind of up in the air, and so I want to give a little bit of closure to that, what ended up getting decided there. And then also, estate recovery was still a little in question at that point as well. And so I want to give some closure to that. Just as a side note, these presentations obviously are videotaped. They end up both on our website and out on YouTube. And so if there are topics from the past or things we know we've talked about before, and you can't put your hands on the materials, or that's all gotten buried under a pile of co-op receipts by now, just know that you can go out and Google or check that out and rewatch those videos. I can't imagine why you want to spend your free time watching me, but it does come in handy on occasion. And then also some new things in 2014 is the new ag tourism law. That's of interest to folks who have farm tours out on their farms, dairy breakfast, that sort of thing. So we'll talk a little bit about that, as well as kind of a really important topic for what I do in estate planning is that Wisconsin adopted a completely new trust law this year. And so I'll give you just a little bit of some of the features of that new law and what that might mean for you. So starting out with this implements of husbandry. There had been law on the books, always, restricting the weight and width of equipment on the road. But there was this conventional wisdom that, well, if it's an implement of husbandry, we don't have to worry about any of that stuff. Well, there were some state troopers over in my home county, Marathon County, who said, you know what, I think it's time to start enforcing those. And then that started happening out in this neck of the woods as well. And so it kind of created a stir around the state. My dad sort of enjoyed it because he got some free loads of manure. My parents' farm was right across the highway from a county garage where there was a scale, and so they would get pulled in and said, you can't move, and rather than, leaving a nice tanker full of manure sit and cook in the sun, they'd say, hey, could we just take it across the road? And, so it worked out okay for us. But so after this stir, they decided, okay, we're going to have some study groups. There was a series of public hearings. I know you might have gotten some notice from us about one that was happening maybe in Chippewa, and ended up with a new law. I've got the Act reference on there, and it does have, nothing about this law is clean and easy to understand, because there's different dates of different things happening over time. And because this whole thing is so confusing, I've got a couple of extra handouts aside from my slides in your folders. There should be a one-page, and imitation is the sincerest form of flattery, our Wisconsin Farm Bureau sent you today. There's a two-sided from the Wisconsin Farm Bureau that kind of gives an overall of this. There's also, I threw in there the Legislative Council memo that gave their big picture of what the legislature thought it was doing, as well as there's a sheet in there that says Act 377 Local Government Options. It's kind of a grid. So hopefully those things will be helpful for you, both as I'm kind of going through this information now and what may be more helpful to you down the road when you're trying to figure out how this thing applies to what you're running on the road. And so overall, it generally increased things about 15% from where it was before. But it also set up this idea of a no-fee permit to be able to exceed the limits. And so some of those limits are still much lower than some of the things we're running down the road with today's equipment. And so there is this no-fee permit process set up, which may or may not apply to you, depending on what municipality you're in. So more clarity here, right? And so I do have that warning on there. The local municipalities have until the 15th of January coming up to decide how they want to respond to this thing. And that's what that grid is laying out. So, you know, it's not uncommon that some of my farm clients also sit on their town boards. And so just know that one of your options is a total opt-out. We don't want any limits. Run anything down the road. That's one of the options that a local municipality can adopt. So, how the heck do you know what your weight limit really is? Can I run this piece of equipment down the road or can't I? You got to ask a series of questions. What am I driving? Because they've set up a couple of different categories of vehicles. And they've redefined the ones that were already there before. So there is still a category that's implements of husbandry. And there's various classes within that. And if you look at that Farm Bureau slide sheet below the line, they kind of lay that out. The tractors are category A, and so there's a variety of categories. So that's one of them. Then they've also set up this idea of the ag commercial motor vehicle. So that's the CMV that's on the slide there. Ag CMV is an ag commercial motor vehicle. So those are vehicles that were really set up to drive for any purpose, but may have been adapted now more specifically for ag purposes. So they still don't necessarily have to be licensed, but they have a whole different category of what the regulations are for those. Or is it none of the above? Is it still being treated as just a normal commercial vehicle like any other semi running down the road? And so that's a whole different set of categories. So first of all, you got to figure out what you're taking down the road. Then you got to figure out, where am I? Where am I going? And how far is it going to be to get there? Because as I said, the local municipality can set their own rules, either to completely adopt what the state has done, to opt out of what the state has done, to set their own limits. And oh, by the way, the seasonal posting and weight limits on bridges and all of that, that's all still there. So they can still do all of that. If you are only going what they call incidental movement, less than a half a mile, that doesn't get us very far. I mean, my parents' two farmsteads were in the same section and we couldn't get from point A to point B in less than a half a mile, but that doesn't count. So you can move a half a mile without having to comply with any of the restrictions. And so then here's where I say, do other restrictions apply as well? So, you know, has something been, you know, posted seasonally because the roads are soft, or the bridges, that kind of thing. Then on the width side of the equation, so all that was kind of talking about the weight restrictions. On the width side, there are new lighting requirements that are going to be coming into play, various flags and reflective material. We've still got the whole slow-moving vehicle sign and those kind of things. That's still out there, as well as this idea of escort vehicles, depending on how wide your piece of equipment is on the road. So, all of that clear as mud? Probably. And so I'm hoping that those resources that I've provided to you will be helpful. The DOT has its own spot out on its website working through all of these things. How the weight and height, not height, weight and width, how those apply. But I will just say that as I was poking around trying to come up with resources, I'm always trying not to recreate the wheel. And so as I was poking around, I really thought the Wisconsin Farm Bureau Federation had some really good resources out there. I've given you the one that is that summary sheet. But they've also got some videos. So if, you know, you're more of a visual kind of person and, you know, reading all this fine print is not your idea of how to figure out how all this stuff works, their videos up there are really great. So they're definitely more resources out there. Like I say, I'm just kind of giving you a taste here of some of the things that are out there, just so you're aware. Okay, so next, estate recovery. So, quick recap. In Wisconsin, if you go into a nursing home, the bill's going to have to be paid. And you can pay that privately, you can have insurance to pay that bill, or you can ask the government to pay through the medical assistance program. Medical assistance is a welfare program, so there are income and asset limitations before the government will say, yes, we will pay for you. There is some flexibility when you're a married couple. One spouse who's at home, one goes in the nursing home. There's a portion of the assets that will be unavailable and protected for that spouse who's at home. So your home and contiguous acreage up to $750,000 is not considered. Your business and income producing assets are not considered. You look at the pool of available. If we are at about 200,000, half gets used for the spouse who's in the nursing home, half also protected for the spouse who's at home. So that's the front end of the process. Now we've gotten qualified, we're on medical assistance, and 2 years ago, if we made it through that, so most of the farm assets ended up in the unavailable pile, we didn't have a ton of cash in the bank, we've got farm assets, we could get qualified pretty quickly usually if one spouse went in for someone to be able to get on medical assistance and have the government assist with those charges. Once we did that, and we made it through the qualification process, everything that was in that unavailable pile, we could start getting rid of. We were good. So we could start gifting to the kids or doing what we need to do with those assets. All of that changed last year. And this is where the idea, some of it that's come out in the media is it's an unlimited look back or it's 2 5-year look backs. That's where that comes into place, is the idea of this after the fact. So we've been qualified. Number one, we can't move around those assets that are otherwise protected. We could still hold them, but we want to keep those in that overall marital pot, because after the second spouse passes away, medical assistance is going to come with their handout and say, you know what, we paid $30,000, $50,000, $100,000 on your behalf. You've got this whole pot of assets left. We want to get that back. And that's what estate recovery is about. And so when we talked last year, we weren't sure exactly how these new rules were going to get implemented, what was going to happen to planning that we already did in the past. And so the good news is, well, first of all, I also said it's likely these laws are going to be challenged. They haven't been challenged yet. Stay tuned on that. I'm sure there's going to be more to come. But the good news is we did get a certain measure of certainty on things. So if you've had people in your family gift homes and retain life estates or do other sort of planning, there's a magic date that they set, the line they drew in the sand that said, if you did it before August 1st of 2014, we're not going to come back after those assets. After that, everything's fair game. So I did a lot of signing up of revocable trusts and other things this summer to try to beat that date. So, the good news is if you've already done planning, at least at this point, they're saying they're going to honor that. So that's some measure of relief on some of those. But after that, our protections are much smaller. This whole topic could be the whole day here today, so I'm just giving you a bite, but I just wanted to give that update just because things were so uncertain, and to also hopefully give some peace of mind that if you had parents or things in your family that had done some planning, that they won't be able to come back after some of that stuff. But if this topic is of interest to you and you weren't here last year, I would encourage you to look at that as well. And then it can be very fact specific as well, these analysis. And so don't hesitate to ask some questions, and we'll be hanging around after as well. Next on our hit list is a new law passed this year called the Ag Tourism Law. And so this is covering, it's kind of a growing area in agriculture of having these agricultural experiences. So we're trying to get people out to the farm, help them understand, what farming is about. We forget that there's people who have, never been around tractors, have, never petted a calf before, those kind of things. And so there's sort of this movement about these ag experiences. The problem is we worry, we've got kids around animals, we've got machinery, what happens if somebody gets hurt? And so this is a response to this, the idea being encouraging people to, have people come out to the farm, learn about agriculture, while limiting their liability. So recreational immunity is something that's been on the books for a long time. It was originally referred to as the berry picker statute. So you could let people come out to your place to pick wild raspberries and not have to worry about getting sued if, if they ran into the old barbed wire fence. The place where I think it's probably more familiar to people now is hunting access, allowing people to hunt on your property. Recreational immunity says that you don't have duties to those folks under certain circumstances. So what the new law has done is add another set of activities to that immunity, which is this ag tourism. So farm tours, other kinds of experience, the pumpkin patches, the corn mazes, that kind of thing. And I've got the act reference in there. I didn't give you the whole legislative piece, but certainly you can find that out on the internet if you're interested in more information. But here are the limitations. Number one, you have to post. So here's the fun disclosure of what you have to post by every entrance to your agricultural experience. I've got it on the slides, hopefully a little easier to read. I mean, some of the things on here I'm sure will be pretty shocking to you of, warning people about the unpredictable behavior of farm animals. I mean, I'm sure none of us have ever been kicked by a cow or a horse or had our foot stepped on or anything else. So a lot of this, I think, to probably the people in the room is common sense. We can question whether anyone's actually going to read this, how big of a sign you're going to need to fit all that language on, and whether that really does anything. But that's what the law says we have to do. You only have immunity if whatever injury happens is due to the inherent risks of the activity. So you can't funnel people through your barn, have taken the grate off over a gutter, and watch them all fall into the hole and say, I'm immune, okay? So you get a common sense thing. If there's open, notorious dangers, you can't walk them into that. You also can't act, it doesn't make you immune from intentional acts. So if that little high school kid who's been lipping off all day, you got that temptation, no, you're not immune. You're not immune. And intentional acts wouldn't be. One of the examples in the law was the idea that if you're driving drunk on your four-wheeler and run over somebody, you're not going to be immune. But here's the bigger catch. You can't charge more than $2,000 in total within the year for that recreational activity, or you lose that immunity. You're not just being a good Samaritan and a good steward of agriculture and inviting people for free out to the farm. You're running a business, and so we're not going to give you that immunity. So if you're charging $5 to go through the corn maze and you've got too many people run through there, you're not going to get that immunity. Same deal, I've got clients with property in Buffalo County, and you can get some good money for renting out hunting rights down there in big buck country. And so that $2,000 you can run up in a hurry if you've got any amount of land. So long story short, it's not a bad thing, but it's not the catch-all for everything. So just, throwing on the lawyer hat for a minute with all of this, I guess in my mind, immunity is great, but it's not a guarantee not to get sued. So, what will often happen here, and I mean, there's been cases about horseback riding places seem to be the magnets for these kind of lawsuits just because the injuries can be so, severe if something happens. They can still sue you. Then you make the motion to say, no, kick out the case. I'm immune from liability because of this law. And so that's why I say this law, even if you're not charging, even if you think you're going to comply, it's not a substitute for insurance, because I think that the best thing that insurance buys you is a lawyer to make that motion for you. So you don't have to go out and hire somebody. Your insurance company would be interested in defending, relying on anything that could get the case kicked out so that they don't end up having to pay anything on your behalf. So good to know about, lots more good information. We got a couple of people in the room who can give more information. There's more available on the internet, or I can give you more as well. Again, we're kind of doing bite-sized portions here today. But so, good thing, not without its catches. Finally, this new trust code. So, Wisconsin completely threw out its old trust law as of July 1st and replaced it with a new law. That doesn't mean that if you had a trust before, that it's invalid. It's going to be interpreted under the new laws. And what I like about this law is kind of the touchstones are, number one, rubber stamping some of the things that we were doing in the past, hoping that they would be enforced in Wisconsin. And number two, flexibility. There was a lot of trust planning done back in the day where we had to worry about an estate tax applying if you had more than $675,000 worth of assets. Try finding a farm that's not worth at least $675,000. So there were a lot of life insurance trusts and things that were set up, and the kind of trusts that couldn't be changed, were irrevocable, that were set up. Now that we're in an environment, and Tammy gave us those limits, the estate tax amount now, the amount you can pass tax-free is $5.34 million if you're going to die yet before the end of the year. Starting next year, that's going up to $5.43 million, and that number is going to keep going up. Some of these old trusts, some of this planning that we had, just doesn't make sense anymore. But our hands were tied because a lot of those trusts were irrevocable. The new law gives us some pretty clear steps about how we can get ourselves out of old plans that are now bad plans because of the change in the law. So both with being able to do that completely outside of court, by agreement of all the relevant parties, and it defines of who those people are that have to sign off, or giving us some court processes as well that give the court some discretion to make those changes. Courts generally don't like to interfere with the intentions of what someone's put in paper who's now passed away or maybe is now incapacitated and can't say that, that's not what they want anymore. Courts like to stay out of that, and so sometimes it's hard to talk them into, but it doesn't make sense anymore. And so this new law gives us some clear authority to the judge to say, look, judge, right here in the law it says you can make this change. We can do this. So I'm excited about that because while I write a lot of trusts now, I've been doing this for 8 years, I see a whole lot more trusts that were already written before I came along. And in some instances I've said, there's just really nothing we can do. Well, now we've got some flexibility of some things we can do. The other features of the law that I really like are some different roles that you can cast people in. So generally a trust has 3 parties involved. It has the person who put in the assets, the grantor or the settlor. You have the person who is in charge of the assets, of managing the assets and distributing them. That's the trustee. And then you have who gets the benefit of those assets, the beneficiary. So we used to just have this triangle. We've got 3 people involved. So it wasn't uncommon for me to talk to a family and they say, you know what, we want a trust as our way of figuring out how our estate is going to pass. But here's the thing. We want the farm to stay in the trust for a period of time. And we've got some non-farm kids and some farm kids. And we want the farm kids kind of to be in charge of the farm. But we want everybody to kind of benefit from it. So, so there was a period of time where we want everybody to get the benefit, but, we don't want the non-farm kids telling the farm kids how to farm. But then if you pick the non-farm kid to be the trustee, well, really they're in charge of everything. And so they kind of have to be second guessing, what's happening, why do we need this more land, why are we, changing feed companies, those kind of things. But on the other hand, if we put the farm kid in charge, sometimes the non-farm kids are going, what the heck? We've got no idea what's going on. We've got no information. How do I know what's happening here? So the bottom point there, these directed trusts is one way we can deal with that. It's kind of splitting that trustee role, and you can specifically designate, hey, this part of the operation is going to be managed by this person. But we're still going to have our trustee that can kind of keep an eye on everything. But they're also not responsible for what happens in this little part over here. Another place where this can come into play is if you've got some significant cash assets, you've got investments, maybe we delegate to the financial planner that we've been using. He's going to have the job of managing the investments. And my kid, who knows nothing about it, doesn't have to be responsible for that if a bad decision is made. Because sometimes, casting kids in these roles, and maybe some of you are cast in the roles for your parents' plans, it can be kind of overwhelming to manage all this for somebody else. And so that's a way to kind of split those roles. The other one that I really like is this trust protector. So we have our 3 roles, and we've picked a trustee to be in charge. And when we're not around anymore. And so now we're gone, and that trustee is acting, and you know what? They're not doing a good job. Or they're doing things wrong, maybe not doing the job at all. And now what? Most of the ways of getting that changed require that trustee that maybe somebody in the family thinks isn't doing a good job to agree that they're doing a bad job. And agree to step down. Well, guess what? That often doesn't happen, particularly when families are disagreeing. And so this trust protector is another person you can pick, another trusted person, and you can give them as much or as little leeway to step in and intervene as you want. And so one of the most common ways that a trust protector is used is just that ability to remove the current trustee. So that trust protector acts, they sign off saying, it's time for a change, and it's done, period, paragraph. We don't have to worry about beneficiaries agreeing, we don't have to worry about the court getting involved, and so this can be nice if you've got small kids and we've got a trust plan for, the assets being held until they're 25. Maybe you have a sibling or a trusted friend who might be able to step in and say, hey, I'll keep an eye on this. They don't have any other liability, they just have whatever authority you give them. And so that can be just a nice little tool, just another protection, another set of eyes, but without asking someone else in your family to kind of sign up for some fiduciary liability that, well, you're involved now, and so now you're totally involved, and guess what? One of those beneficiaries, might sue you for not doing things right. So it's a more limited role, but just someone else who could, stand in your shoes and do what you might have done under the circumstances had you been there. So touchstones, don't worry about your old trust. It's still valid. But some other ideas for some flexibility and some other roles. Now, sometimes we've got a tough enough time coming up with the people that we're going to serve as trustees, so the idea of having these new people in is overwhelming. None of this is required, all things that we can utilize under the circumstances. One other flexibility item is the idea of being able to take one of those old trusts and doing what they call decanting. I don't know if anybody's ever decanted wine where you pour it out of the bottle and run it through a filter. So it's the same idea. We take the old trust, we draft up a new trust, and we take those old trust assets and just pour them into the new one that works under today's laws, today's circumstances. So that's a nice feature of that. I've covered a lot of ground. All of our speakers have covered a lot of ground here today. I think everyone's given you contact information. Don't hesitate to follow up. I know a number of us will be floating around here after the fact if you have questions that apply just to you, but also open up. Anybody have any questions on what I've talked about here? Okay. If not, thank you